The question that we are going to go over in this lesson is freely available for download on the National Conference of Bar Examiners website, which is www.ncbex.org. If you'd like access to more practice questions like the one we're about to go over in this lesson, simply head over to the National Conference of Bar Examiners website and visit the section on preparing for the exam. From here, you can download tons of free practice questions directly from the National Conference of Bar Examiners. This is an awesome free resource I highly recommend everyone check out. Additionally, if you would like explanations to more bar exam questions in the format of this video, you can always head over to our website at www.studicata.com. But with that, I'm really excited to get into this lesson with all of you, so let's just go ahead and jump right in. In this lesson, we're going to go over a criminal procedure bar exam essay question from the July 2011 multi-state essay exam. So step one, the first thing we always want to do with these types of essay questions is head down to the bottom of the essay first to take a quick look at the call of the question. Oftentimes, the call of the question is going to give us really important information to consider as we begin to actually read our fact pattern for the first time. So if we take a look at this call of the question, it tells us that the state charged suspect with misdemeanor violation of the seatbelt law and felony drug possession. Suspect has moved to suppress all the state's evidence alleging an unlawful stop, an unlawful arrest, an unlawful seizure of evidence, and multiple Miranda violations. Question 1 asks, did the traffic stop and subsequent arrest violate suspect's constitutional rights? Explain. Question 2 asks, did officers' seizure of evidence from suspect's car violate suspect's constitutional rights? Explain. Question 3 asks, did officers' questioning of suspect violate suspect's Miranda rights? Explain. And question 4 asks, should suspect's confession to detective be suppressed? Explain. Okay, so this is a really robust call of the question. Lots of really great information to work off here. Number one, we're really obviously in criminal procedure territory, and it looks like we're going to be dealing with some Fourth Amendment issues, perhaps some Fifth and Sixth Amendment issues, and Miranda v. Arizona, with Miranda violations being alleged. So we can kind of break this down question by question, though, starting with question number 1, maybe develop some issue spotting checklists or just some things to consider here as we begin to read the fact pattern. And we can kind of break each of these down, and then we can actually start reading and analyzing the facts. But let's start with question number 1. Did the traffic stop and subsequent arrest violate suspect's constitutional rights? Explain. So question number 1 looks really like it's about the Fourth Amendment. And specifically, it looks like it's about seizures of a person, right? When we see a traffic stop and subsequent arrest, and we're wondering whether the stop and the arrest violate the suspect's constitutional rights. Well, we know the Fourth Amendment guarantees protection from unreasonable government searches and seizures. This is both seizures of a person and searches and seizures of evidence. Question number 1, we're dealing with seizures of a person. This is not about an evidentiary search and seizure. This is a stop of a human being and an arrest of a human being. So really, the main facts we're looking out for here, we can always think about seizures of a person in terms of kind of like a certainty spectrum. Maybe at like the high end of our certainty spectrum, we have like 100% certainty. And at the low end, we have things like a hunch, right? 100% on this spectrum would mean like a police officer is 100% sure a crime has been committed. And on the lower end, something like a hunch would be like the police officer has a hunch that criminal activity might be afoot. The key to recognize on this spectrum is under the Fourth Amendment, the police can't just stop people and arrest people for no reason or based on a hunch, right? Based on no articulable facts. The police can't just go around stopping people, seizing people, arresting people for no reason, right? At minimum, to stop a person, we know the police have to have a reasonable suspicion. This is Terry v. Ohio. They have to have a reasonable suspicion to believe that criminal activity is afoot. And this reasonable suspicion has to be based on articulable facts. It's got to be more than just a hunch or intuition, right? They need a reasonable suspicion based on articulable facts that criminal activity is afoot to even stop somebody. So number one, we're wondering, okay, at the traffic stop, at minimum, if we're looking back to question number one, did the traffic stop violate suspect's constitutional rights? Well, at minimum, the police officer would have had a reasonable suspicion based on articulable facts that criminal activity was afoot. So that's what we'll be looking at when we're thinking about the traffic stop. The subsequent arrest, we know to arrest somebody, the police have to base an arrest on probable cause, which is even farther along on our certainty spectrum than a reasonable suspicion. So a reasonable suspicion would be required to stop somebody, right? So you could conduct a traffic stop based on a reasonable suspicion, or the police could, right? A government official, usually a police officer, could stop somebody based on a reasonable suspicion. And then when they do that stop, what's called a Terry stop based on a reasonable suspicion, they have to take diligent steps to investigate whether criminal activity is afoot or not. And if they determine that no criminal activity is afoot, then they have to let the person go, right? But on the other end, if they confirm based on the diligent steps they're taking to investigate whether criminal activity is afoot, that a crime is likely being taken place, right? That could lead to probable cause, which could give us an actual arrest, which would be required to arrest a person. So we're thinking about question number one, and we're thinking about a traffic stop and subsequent arrest. At minimum, for the traffic stop, we need the police officer to have a reasonable suspicion based on articulable facts that criminal activity is afoot. This would have to be more than something like a hunch or an intuition. It has to be evidence-based, right? Something on articulable facts, something the police officer can actually articulate as evidence. Hey, it looked like something maybe was going on. There's some sort of criminal activity afoot here. There has to be articulable facts to actually stop our suspect without violating his Fourth Amendment rights. And then to subsequently arrest our suspect without violating the suspect's Fourth Amendment rights, we'll need to see that the police officer has probable cause to believe that a crime has occurred. Okay, so this is kind of what we're thinking about with question number one. It looks like it's going to be an analysis of this certainty spectrum, which takes us to question number two. We can kind of break this down a little bit. Over here, if we look at question number two, did officers' seizure of evidence from suspect's car violate suspect's constitutional rights? Okay, so this is still Fourth Amendment territory, right? This is still Fourth Amendment. But instead of a seizure of a person, this looks like a search and seizure of evidence, right? This is not the actual stop and arrest of a human being. This is search and seizure of evidence from the suspect's car. So kind of our starting point rule here when we're thinking about Fourth Amendment searches and seizures of evidence is the search warrant requirement. If the police are going to physically intrude into a constitutionally protected area, right, a place where a person has a reasonable expectation of privacy, our starting point rule is to search for and seize evidence by physically intruding into a constitutionally protected area. The police need a search warrant. Absent a search warrant, if they just go in absent an exception or a search warrant, right, a warrantless search with no exception could result in a Fourth Amendment violation. So that's what we're going to be looking out for with number two. Now, interestingly, it does look like the search and seizure of evidence here is happening from the suspect's car. And this is really notable, right? We're thinking about the suspect's car because a car, an automobile, is generally not at the same level that we would consider things like a home, right? The constitutionally protected places we're typically thinking about would be something like the home, the hotel, the office of a person, in some cases, luggage, right? These are like your traditionally constitutionally protected areas. These are places where the Supreme Court has held a person has a reasonable expectation of privacy. So when the police physically intrude into these areas to search and seize evidence, if they don't have a search warrant and no exception applies, that can be a Fourth Amendment violation, right? That's a violation of a person's protection from unreasonable government searches and seizures of evidence. So notably, though, in question number 2, it tells us that this is happening in the suspect's car, right? An automobile does not have the same level of privacy. A person doesn't have the same reasonable expectation of privacy in an automobile as they would in something like a person's home, a hotel room, an office, or perhaps their luggage. Now, interestingly, we don't know, we're gonna have to read the fact pattern. If the police officer is searching like a backpack inside the car, right, that could be a place where a person has a reasonable expectation of privacy. It's going to depend a lot on the circumstances here of where in the car is the police officer searching. Are they searching in like a backpack, a container? Are they searching in the trunk of the car? Are they searching in the passenger seat of the car? You know, we don't know. We're going to have to read more. But the starting point kind of question we need to think about on question number 2 is, does the suspect here have a reasonable expectation of privacy in his car? Because if he doesn't have a reasonable expectation of privacy, then the police officer's not violating his Fourth Amendment rights. He's not physically intruding into a constitutionally protected area. Then he's not going to need a search warrant, and it's unlikely there's going to be a Fourth Amendment violation. So when we're thinking about search and seizure of evidence from suspect's car, right, we really are going to be thinking about this concept of reasonable expectation of privacy. You know, does the police officer somehow do this in a way that does violate this person's reasonable expectation of privacy? So it'd be like something like he's searching for going through a backpack inside the car. Something like this could raise interesting issues, but we're just gonna have to read and see. And even if that does happen, we know there's exceptions that could apply. It does look like an arrest is happening. We have things like, search incident to a lawful arrest. That could be an exception to the search warrant requirement. There could be exigent circumstances. So just because it's a warrantless search, that doesn't mean it's automatically a Fourth Amendment violation. There could be an exception where the police officer is physically intruding into a constitutionally protected area. He is violating the suspect's reasonable expectation of privacy, but there's an exception that applies that allows him to do this without a search warrant. So these are just things to think about, but it's going to be very fact specific. We have to see the circumstances of exactly how this search is going down to analyze this more. So those are just the big picture ideas we're thinking about with question number 2. We can take a quick look at question number 3. Right, question number 3, kind of try to determine what issues we're addressing here. Did officers' questioning of suspect violate suspect's Miranda rights? Okay, so this is Miranda v. Arizona, right? When we're thinking about somebody's Miranda rights being violated, the first thing we have to look out for is whether or not there was a custodial, right? We need a custodial interrogation. Was there a custodial interrogation? We can almost think about these like elements. We need a suspect in custody, and we need that suspect to be interrogated while in custody to trigger Miranda. The Supreme Court held in Miranda v. Arizona, before a police officer can conduct a custodial interrogation, the police officer has to inform the suspect of his Miranda rights. And we all know what the Miranda rights are. This would be that the suspect has the right to remain silent. Anything the suspect says can and will be used against him in a court of law. The suspect has the right to an attorney. If the suspect cannot afford an attorney, one will be provided for him, right? A police officer has to let the suspect know these 4 basic Miranda rights before conducting a custodial interrogation. Failure to do so will result in a Miranda violation. So the starting point rule when we're thinking about question number 3, was officers' questioning of suspect a custodial interrogation? If it was a custodial interrogation and he failed to inform the suspect of his Miranda rights, then yes, that could be a Miranda violation. But if it's not a custodial interrogation, then Miranda v. Arizona is not even triggered. So we'll really be thinking about whether we have a custodial interrogation. And just, quick notes on custodial and interrogation. Again, it's best to think about these like elements. So we're going to say a person is in custody when he reasonably believes that he is not free to leave or otherwise terminate the encounter. So we're going to be looking at this. If our suspect, remember, it does look like our suspect is being arrested here if we're looking at question number 1. If our suspect's being arrested, if he's in handcuffs and he's in the back of a squad car, something like this, being arrested, that's going to look like he's in custody. A reasonable person does not feel free to leave when they're handcuffed in the back of a squad car. So if he's in custody and the police, right, the person rather, is going to be considered subject to an interrogation when the police know or should know that their words or actions are likely to elicit an incriminating response. So if we have a suspect in custody, he's being arrested, he's got the handcuffs on, he's in the back of the squad car, whatever, right? He's in custody, and we have the police engaging in actions that are likely to elicit incriminating responses. The police officer's asking him questions. Hey, did you commit this crime while he's handcuffed in the back of the squad car? That very well could be a custodial interrogation. I bring this up because a lot of times people think a custodial interrogation only occurs when a suspect's in a dim lit room with the flashlight in his face, being asked questions by a detective. And certainly this is one form of a custodial interrogation, but there's no, requirement that a person be in police headquarters in an interrogation room to be subject to a custodial interrogation. As long as the person reasonably believes that he is not free to leave or otherwise terminate the encounter, and the police are engaged in actions that are likely to elicit incriminating responses, that's a custodial interrogation. Meaning a custodial interrogation can happen anywhere. It can happen at the scene of an arrest. It can happen, in police headquarters, can happen anywhere. So that's what we'll be looking out for with question number 3. Did the officer's questioning of suspect constitute a custodial interrogation? If so, then that officer had a duty to inform the suspect of his Miranda rights. If he failed to do that, that's where we could get a violation of Miranda v. Arizona, which takes us to question number 4. We'll see if we can kind of figure out what's going on here. Question number 4 asks, should suspect's confession to detective be suppressed? Explain. Okay, unfortunately, there's 100 different reasons a confession could be suppressed. It does look like this is a different setting. So we're going to have the officer questioning the suspect. Then we're going to have a detective questioning the suspect. So it's probably going to be at a later point in time. This again, though, there could be 100 different reasons that a confession could be suppressed. So we'll have to read there to know more. Things we're thinking about, though, just because it's a criminal procedure fact pattern, is this happening before or after charging? When is the suspect confessing to detective would be kind of an important fact I'd want to know. Is this happening in our timeline? We're thinking about the suspect at this point has probably been arrested already. Maybe he's been subject to an arrest. Has he been formally charged with the crime? Once a suspect is formally charged, right, with a crime, we know their Sixth Amendment right to counsel automatically attaches. So if our suspect's confession happens once formal adversarial judicial proceedings have begun and his attorney is not present, that's where we could get into possible Sixth Amendment issues. That could be a violation of his Sixth Amendment right to counsel, which could be grounds for suppressing the confession. If it's before formal charging, we'll have to think about Miranda again. This could be another Miranda issue. It does look like the call of the question, if we look back up here, that there are multiple Miranda violations being alleged. So that would lead me to believe we're probably over here somewhere in the timeline. before formal charging. And it looks like this could actually be a separate Miranda violation, which would kind of be more aligned with like Fifth Amendment right to counsel. So we'll have to see if there's a Fifth Amendment right to counsel issue, maybe a subsequent Miranda violation. We could have multiple Miranda violations. Again, though, we're just going to have to read here. We don't know based on question number 4, should suspect's confession to detective be suppressed? There's just a ton of scenarios where we could have the confession being suppressed. Even evidence issues could be brought in outside of, traditional criminal procedure analyses. So we'll just read the fact pattern and break this down kind of point by point as we go through it. So we can just go ahead, though, and start with paragraph number 1. Paragraph number 1 tells us that a police officer on routine traffic patrol watched suspect drive by. Suspect was in compliance with all applicable traffic laws except the state seatbelt law. The state motor vehicle code provides that police officers have discretion to make an arrest for any traffic infraction, including violation of the seatbelt law, the state seatbelt law. Officer had never stopped a driver merely for violating the seatbelt law. However, officer knew that suspect was a reputed drug dealer and stopped suspect's vehicle, hoping to uncover evidence of a more serious crime. Okay, so this is where we get into question 1 issues, right? Our first paragraph looks like it's going to be about question number 1. This is where we get our actual stop. Right here at the end of the paragraph, we do see that officer had never stopped a driver merely for violating the seatbelt law. However, officer knew that suspect was a reputed drug dealer and stopped suspect's vehicle, hoping to uncover evidence of a more serious crime. So remember, the only analysis here, we already talked about this, in terms of whether the stop is lawful under the Fourth Amendment would be whether he has a reasonable suspicion that criminal activity is afoot based on articulable facts. And here he does. Right now, we have all this stuff about the fact that he's a drug dealer and he's hoping to uncover evidence of, a drug crime. That doesn't really matter in our analysis, though, because he does have a reasonable suspicion. In fact, he has even more than a reasonable suspicion that this state seatbelt law has been violated. He probably has probable cause, right, based on his own personal observations. If a person drives by without a seatbelt on and the police officer personally observes this, then he's got probable cause to believe criminal activity is afoot. He can absolutely stop that car and make an arrest if the state seatbelt law says he can do so, which it does. The state motor vehicle code provides that police officers have discretion to make an arrest for any traffic infraction, including violation of the state seatbelt law. So this statute gives him the ability to make an arrest for any traffic infraction, so long as he has probable cause to believe that a traffic infraction has occurred, which it looks like he's personally observed this driver not wearing his seatbelt. So that would be probable cause to make the stop and a subsequent arrest. Right there, we pretty much have our answer to question number 1. Right? Did the traffic stop and subsequent arrest violate suspect's constitutional rights? Now we'll have to see what happens with the arrest, but so far, the traffic stop itself does appear to be lawful. No Fourth Amendment violation for the traffic stop at this point. Now, the bar examiners threw in all these other facts basically to try to trip you up a little bit about the fact that he's a reputed drug dealer and he's hoping to uncover evidence of a more serious crime. That's irrelevant in our Fourth Amendment stop and seizure of a person analysis, right? What the officer's personal motivations are, don't matter. And in fact, this happens all the time, right? Police go out and they'll even follow somebody that they believe, has committed a more serious crime. They'll go out and wait for this person to, make a minor traffic violation so that they can stop them. Whatever the police's motivations are don't really matter as long as they have probable cause to believe that some crime has been committed. They can make the stop and they can make an arrest based on that probable cause. What their underlying pretextual motivations are not going to be relevant in the analysis of the Fourth Amendment, whether that suspect's Fourth Amendment has been violated due to an unreasonable government stop or seizure, right? Whatever the officer's motivations are not a part of that analysis. So we don't want to get tripped up by, the officer's personal motivations here, or whether the officer had ever stopped a driver before for violating seatbelt law, right? The fact that the officer knew he was a drug dealer and was hoping to uncover evidence of a more serious crime, right? All of that stuff, officer motivations, not going to be relevant in our Fourth Amendment analysis. But noted, right? With that, though, we can move on to paragraph number 2. Paragraph number 2 tells us that officer directed suspect to get out of his vehicle, handcuffed suspect, and told suspect that he was under arrest for violating the seatbelt law. Okay, again, this is within the scope of the Fourth Amendment. The officer is absolutely allowed to make an arrest based on probable cause. And he has probable cause here to believe that this suspect has violated the seatbelt law. He personally observed, he personally witnessed the crime take place. So he's got probable cause to stop the suspect and make an arrest. At this point, the Fourth Amendment has not been violated. Officer directed suspect to get out of his vehicle, handcuffed suspect, and told suspect that he was under arrest for violating the seatbelt law. Okay, so again, that first sentence still kind of goes to question number 1, but we can keep reading. Immediately afterward, officer looked through the driver's side car window and noticed a clear plastic bag containing white powder on the front seat of the suspect's car. Officer asked suspect, "Are those drugs yours?" Suspect responded, "No, that cocaine isn't mine." Officer then opened the car door and removed the bag of white powder. Okay, the rest of this paragraph, we do have some other issues going on here. This goes to both question number 2 and question number 3 at the same time. We can start with kind of the question 2 aspects of this paragraph, though. And so question 2, we do see the actual search and seizure of evidence happening here, right? Officer looked through the driver's side car window and noticed a clear plastic bag containing white powder on the front seat of the suspect's car. So immediately, this to me is triggering the plain view doctrine. Remember, with question number 2, we said a big aspect of this question is going to be whether our police officer is physically intruding into a constitutionally protected area. A place like the home, the hotel, the office, maybe some piece of luggage in the car. This would be kind of our trigger for the police officer having to have a search warrant. Because it does look like this search and seizure of evidence is happening without a search warrant. So we are wondering, is there some sort of exception that could apply here that would allow the officer in this case to search and seize this evidence without a warrant? And the first thing that obviously comes to mind is the plain view exception. Even though there's a lot of things that we could talk about here as to why the officer is probably allowed to do this. Number 1, like we said, the automobile itself really isn't the same type of constitutionally protected area that like a home or hotel is. So really, for Fourth Amendment purposes, this isn't even a search, right? How we would define a search under the Fourth Amendment. I mean, our police officer is in a lawful position on a public street, right? A police officer doesn't have to wear a blindfold when he's arresting someone and not look in the car. He's absolutely allowed to stand on the street and look in a window, right? That can't possibly be a Fourth Amendment violation. And the kind of most relevant, though, rule we have here to this type of fact pattern would be the plain view doctrine. Under the plain view doctrine, we kind of get 3 elements. We say police may seize evidence without a warrant if the police are, number 1, lawfully in a position from which they view the object. Element number 2, the object's incriminating character is immediately apparent. In element number 3, the police have a lawful right of access to the object. Now, the lawful right of access to the object element isn't going to be really relevant here because we're dealing with a parked car on a public street. It's not really a constitutionally protected area. This lawful right of access to the object would be more of an issue if we were dealing with like the home, a hotel, or office. If it was the exact same fact pattern and we had a police officer see, cocaine through a window of a home, just because he sees cocaine in plain view through the window of a home, right? That doesn't give him the right to enter somebody's home and seize the cocaine without a search warrant. He doesn't have a lawful right of access to the object. Now there could be exigent circumstances. There could be an exception there that would allow him to go in and seize the evidence anyways. But, just for our purposes with this fact pattern, the 3 elements here, again, the police, when we're thinking about under the plain view doctrine, police may seize evidence without a warrant if the police are lawfully in a position from which they view the object's incriminating character is immediately apparent, and the police have a lawful right of access to the object. This police officer is going to have lawful right of access to the driver's passenger seat because it's not really a constitutionally protected area like a home might be, a hotel might be, or an office might be. So that third element's really not going to be an issue here. Our first element, yes, the police officer is clearly in a lawful position when he sees the object, right? He's just standing on a public street, that there's no issue there. He's lawfully where he's supposed to be. And the object's incriminating character, it becomes immediately apparent. This is probably why the bar examiners give you this fact that the suspect responds that the cocaine isn't mine, right? The suspect responded, no, that cocaine isn't mine. This makes the object's incriminating character immediately apparent. The suspect, before he said that, maybe could have tried to argue that the plain view doctrine shouldn't apply because, that could have been a bag of salt. That could have been a bag of sugar, just a baggie of white powder, right? Is that the type of object where the incriminating character of the object is immediately apparent? Under the plain view doctrine, the object's incriminating character has to be immediately apparent, right? The officer's not allowed to examine it to determine whether it's incriminating or not. It has to be immediately apparent, right? So there could be an argument, no, that was salt, that was sugar, that wasn't cocaine. But it becomes, if there was any question as to whether the incriminating character of the object was in question, when the suspect says, no, that cocaine isn't mine, now it becomes very clear, very apparent that the object is contraband. This is cocaine. This is an illegal drug. So all 3 elements are going to be satisfied here for the plain view doctrine to apply. Under the plain view doctrine, police may seize evidence without a warrant if the police are lawfully in a position from which they view the object's incriminating character is immediately apparent, and the police have a lawful right of access to the object. Again, because this is a parked car, police are going to have a lawful right of access to this cocaine. If the cocaine was being seen through a window into the suspect's home or hotel or office, this could be different. Maybe then the officer wouldn't have a lawful right of access. But a parked car on a public street, this requirement does not bar the seizure of evidence in a parked car. And the idea there is because a person doesn't have the same type of reasonable expectation of privacy in a parked car on a public street that they might have in their home or their hotel room or an office, or, even if this was like luggage inside the car. If he was retrieving, if he went into a backpack in the suspect's car, that could be different too. But just the fact that it was sitting there on the driver's side car window seat, that lawful right of access to the object is very clear in that circumstance. Okay, so it looks like with question number 2, when we're thinking about whether this was an unreasonable government search and seizure of evidence, for several reasons, the answer is going to be no, but probably the most applicable in this fact pattern is the plain view doctrine. And, this should be somewhat intuitive. I mean, I just like to think about it like a police officer wouldn't wear a blindfold when they're arresting somebody. Like if they see clearly in the driver's seat some drugs or some other illegal contraband, of course they can take that, they can seize the evidence. I mean, that's just the plain view doctrine. This would be more interesting if it was happening like in somebody's home or hotel room. If the arrest was happening outside the home and the police officer saw through a window, drugs inside the home, the plain view doctrine would not apply because he might not have a lawful right of access to the object. But again, parked car, that's less of an issue. This makes it a little bit easier to grapple with this fact pattern very clearly under the plain view doctrine. This is not a violation of the suspect's Fourth Amendment protection from unreasonable government searches and seizures. Okay, so that's what my kind of question number 2 analysis of this paragraph looks like. The question 3 analysis, we're thinking back to question number 3, did officers' questioning of suspect violate suspect's Miranda rights? This one's interesting. We see here that our officer asked the suspect, are those drugs yours? Right here, officer asked suspect, are those drugs yours? And then suspect responded, no, that cocaine isn't mine. So the question is going to be, remember, we're thinking about question number 3, is that a custodial interrogation? When the officer asks the suspect, are those drugs yours? Is the suspect in custody? And is that words or actions that the police officer should have known was likely to elicit an incriminating response? Remember, a person is in custody when he reasonably believes that he is not free to leave or otherwise terminate the encounter. So would our suspect here, when he's handcuffed and being told that he's under arrest, would our suspect be able to reasonably believe that he is free to terminate the encounter? Can he just walk away and go on with his day? No, right? A reasonable person in that circumstance would understand that they're not free to leave. So that means, yes, he's in custody. Is he being interrogated by a police officer? Well, a person is subject to an interrogation when the police know or should know that their words or actions are likely to elicit an incriminating response. Officer asks the suspect, are those drugs yours? Right? Would an officer know, or should an officer know, that those words, that question, asking, are those drugs yours, is likely to elicit an incriminating response? You're literally asking the guy whether or not he is in possession of an illegal substance, right? That is like the most obvious kind of way to elicit an incriminating response. So that's definitely an interrogation. So we have a police officer who is conducting a custodial interrogation, right? Suspect is in custody and he's being asked questions by his police officer that are likely to elicit an incriminating response. That's an interrogation. Therefore, under Miranda v. Arizona, this police officer had a duty to inform this suspect of his Miranda rights, that he's got the right to remain silent. Anything he says can and will be used against him in a court of law, that he's the right to an attorney. If he can't afford an attorney, one will be appointed for him, right? Which our officer, according to these facts, fails to do. Does not inform the suspect of his Miranda rights, but still conducts a custodial interrogation when he asks if the drugs are the suspect's. Therefore, to me, that does look like a violation of Miranda. We're looking at question number 3. Did officers' questioning of suspect violate suspect's Miranda rights? I would say yes. He conducted a custodial interrogation without telling the suspect what his Miranda rights are. It's a clear violation of Miranda. A little bit tricky, obviously, because we have to recognize that one question, are those drugs yours, does constitute a custodial interrogation. So that's a little bit tricky. I could see students getting tripped up with that question. But nonetheless, I do think that is a Miranda violation when we're thinking about question number 3, which takes us to our last paragraph. This is where we're going to get to the confession to the detective and whether this should be suppressed or not. So we're going to have to see what's going on here in this last paragraph, which tells us that the officer transported suspect to the police station for booking. An hour later, detective visited suspect in the police station holding cell to attempt an interview. Detective read suspect his Miranda rights. Detective read suspect his Miranda rights. Suspect stated that he understood his Miranda rights, but nonetheless would answer detective's questions. Suspect voluntarily answered detective's questions for about 5 minutes and then said, "I'm not sure about this. Maybe I need a lawyer." Detective did not seek clarification of suspect's statement, but continued to question suspect, who ultimately confessed to possessing the cocaine found in his car. Okay, so this just looks like another kind of Miranda analysis, right? We don't have to worry about whether the confession is voluntary or involuntary. That could raise Fifth Amendment issues because it tells us that the suspect voluntarily answered detective's questions. So that kind of takes Fifth Amendment involuntariness potential issues off the table. And we don't have to worry about the Sixth Amendment right to counsel because the suspect is not formally charged with a crime at the time this interrogation is taking place. If the suspect had been formally charged with a crime, if we saw formal judicial adversarial proceedings had begun at the time this interrogation was taking place, then his Sixth Amendment right to counsel would have automatically attached. Questioning the suspect in absence of his attorney once the Sixth Amendment right to counsel had attached could be a violation. But again, this is not an issue because he hasn't been formally charged with the crime. Okay, so the only duty the police officer has here kind of left in our criminal procedure analyses is Miranda v. Arizona, has to read the suspect his Miranda rights, which he does. So, but because obviously this is a custodial interrogation. He's got him in police. This is like the traditional custodial interrogation. Takes the suspect to a holding cell, an interrogation room. He's obviously in custody. He's obviously being interrogated. So it's clear that this one's a custodial interrogation. But this time the police officer does read the suspect his Miranda rights, which he's supposed to do. So the questioning begins, and the suspect voluntarily answered the detective's questions for about 5 minutes, and then said, "I'm not sure about this. Maybe I need a lawyer." So we do know under Miranda v. Arizona, if at any point during the interrogation, the suspect asks for his attorney, unequivocally, unambiguously asserts his Fifth Amendment right to counsel, then the interrogation has to stop. It has to cease at that moment in time. The police officer cannot continue questioning a suspect once he affirmatively invokes his Fifth Amendment right to counsel. The problem is the suspect does not affirmatively invoke his Fifth Amendment right to counsel when he says, "I'm not sure about this. Maybe I need a lawyer." That is not unambiguous, right? When somebody says, "Maybe I need a lawyer," that's not an affirmative invocation of their Fifth Amendment right to counsel. So at that point, the detective is free to continue questioning him. Right? Detective can say, "Oh, that's your call. I don't know if you need a lawyer. It's up to you, man," and continue questioning the suspect. If the suspect had said, "I need a lawyer. I want my lawyer. I'm not going to answer any more questions until my lawyer is here," that would be an affirmative invocation of his Fifth Amendment right to counsel, and questioning would have to cease at that moment in time. But saying, "I might need a lawyer," or "maybe I need a lawyer," that's not enough. That's not an affirmative invocation of his Fifth Amendment right to counsel. So the police officer or the detective here is allowed to continue questioning. That's not a violation of Miranda v. Arizona. There's no issue there. So that's what I'm thinking the answer to question number 4 is going to be. This kind of just looks like a textbook interrogation. Takes him into custody, had the duty to read him his Miranda rights, which he does. The suspect volunteers to speak to the detective. That's fine. 5 minutes in, says, "I'm not sure about this. Maybe I need a lawyer." That's not an affirmative invocation of his Fifth Amendment right to counsel. So the police officer is permitted to continue questioning him. That's not a violation of Miranda v. Arizona. The only other like possible sub issue I could see here is like fruit of the poisonous tree. If we're saying in question number 3 that there was a Miranda violation, if this police officer's conduct amounted to a Miranda violation, then the suspect's statement that no, the cocaine isn't mine, that statement by the suspect where he says up here, no, that cocaine isn't mine, that's a violation of Miranda. That statement could be suppressed. And we get this idea of the fruit of the poisonous tree doctrine, where if there's a Fourth Amendment violation, a Fifth Amendment violation, or a Sixth Amendment violation, derivative evidence obtained as a result of those violations, we say is tainted as fruit of the poisonous tree. So in a lot of instances, and unless an exception applies, the derivative evidence along with the original violation are all suppressed. They're all inadmissible. The original violation plus the derivative evidence under the fruit of the poisonous tree doctrine. Now, it's very notable that the fruit of the poisonous tree doctrine does not apply to Miranda violations. So there could be some sort of sub-issue here about whether this confession to the detective is tainted by the earlier Miranda violation, but the answer to that question is also going to be no, because fruit of the poisonous tree doctrine does not apply to Miranda violations. The only issue you'd have to look out for there would be if there was some way that the questioning from the officer all the way to the confession to the detective could somehow be construed as like a single unwarned sequence of questioning, but there's just no way that would apply here. I mean, it's clearly not the case where we have the suspect being taken from the arrest scene where the Miranda violation occurs to the police station for booking, where we have an hour passing in time before the detective even visits the suspect for questioning, right? This can't realistically be construed as like one single sequence of questioning, where the detective is providing, again, Miranda warnings at a later time in a different place. So from the original Miranda violation. So there's just no way I could see the fruit of the poisonous tree applying here to like somehow taint the further confession. Again, if it was all like one long interrogation, it was one single sequence. There's some case law out there for that, where an original Miranda violation could kind of bleed over because it's one single unwarned sequence of questioning. But the key here is like an hour passes, it's a different officer, we have this new detective, he's a new location, and the detective reads the suspect his Miranda rights at that time. So I don't see the original Miranda violation tainting, the later confession that the police officer gets, because the fruit of the poisonous tree doctrine does not apply to Miranda violations. I think that'll be the key in that analysis. But with that, we've gone through all of these paragraphs. We've kind of gone through the issue spotting here. I think we've touched on all the major issues that are being tested. So from here, we can kind of just go point by point and see exactly what the bar examiners were looking for, starting with point number 1, which was worth 25% of this essay. Here, the bar examiners were looking for examinees to conclude that a traffic stop and arrest with probable cause does not violate the Fourth Amendment, even if the offense was minor and the stop served as a pretext for investigating other criminal wrongdoing. Okay, this goes back to paragraph number 1. We already talked about this. The idea is it doesn't matter what the police officer's own motivations are. The key to point 1 was basically recognizing that under the Fourth Amendment, the constitutional reasonableness of a traffic stop and subsequent arrest does not depend on the motivation of the officer involved or the petty nature of the offense charged, so long as state law permits an arrest. So the rule here is Simple. If the officer has probable cause, which he did, to believe that a suspect has committed an offense, then a stop and arrest of that suspect is constitutional if it's authorized under the applicable state statute, which we had here, right? The state statute says that it includes violations of the state seatbelt law. So the state statute says, hey, if the officer sees somebody violating a traffic law, including the state seatbelt law, they can make an arrest. So all we would have needed, since we had that statute on the book, is probable cause to believe that this traffic violation has occurred. And here we have a personal observation from the police officer. So because the police officer has probable cause to believe that this seatbelt law has been violated, that gives him the right to make an arrest. It doesn't matter what his own personal motivations were. The fact that this was a reputed drug dealer, right? And he's hoping to uncover other evidence. All of those facts are irrelevant because he had probable cause for the original traffic stop violation of this seatbelt law. So he can make the arrest. There's no Fourth Amendment violation there. That was question number one, or point number one, which was worth 25% of this essay, which takes us to point number two, which was also worth 25% of the essay. Here, the bar examiners were looking for examinees to conclude that the officer's seizure of evidence from the front seat of suspect's car did not violate the Fourth Amendment. This was basically just the application of the plain view doctrine. Remember, under the plain view doctrine, police may seize evidence without a warrant if three elements are satisfied, right? If the police are lawfully in a position, if the police are basically in a lawful position when they view the object's incriminating character is immediately apparent, right? And number three, the police have a lawful right of access to the object. So we would say police have a lawful right of access to the object. Here, it seems pretty clear that all three elements are met. If we look back to question number two, the police officer is lawfully in a position from which he views the object. He's in a lawful position, right? He's on a public street. If the police officer had physically intruded into a constitutionally protected area, remember, we noted that the home, the hotel, the office, luggage can all be constitutionally protected areas where a person has a reasonable expectation of privacy. But here we see the police officer seize this cocaine, the object, the evidence, from a lawful position, right? He's on a public street, which he can lawfully be, right? A police officer can meander along all he wants on public streets. He's not physically intruding into anyone's constitutionally protected areas when he's on a public street. So our police officer's in a lawful position when he views the object. The object's incriminating character becomes immediately apparent. Remember, the guy tells the police officer, it's not my cocaine. The cocaine isn't mine. When he says the cocaine isn't mine, if there was any question as to the character of the object, even though it would already be very suspect, a baggie of white powder sitting in a car, there's an argument, maybe that's salt, maybe it's sugar. When the suspect says that cocaine isn't mine, well, at that point, the object's incriminating character is immediately apparent. So the second element would have been clearly satisfied. And our third element is whether the police have a lawful right of access to the object. This was really easy because we had a parked car, right? We had a parked car. This is not a place where a person has a reasonable expectation of privacy, right? The front passenger seat of their parked car on a public street, right? The police are going to have a lawful right of access to the object when the object is sitting on the front seat of a parked car on a public street. Again, this could have been different if it was a home, a hotel, an office, or some sort of luggage inside the car, but we didn't have those facts here. Remember, if the police officer was arresting somebody outside their home and they saw from the public street, there's some drugs in that window right there, Well, they don't have lawful right of access to go into a constitutionally protected area without a search warrant, right? That going into somebody's home, unless there were some other facts, where an exception could apply, like exigent circumstances, maybe a child's playing with the drugs in the house, it's an emergency situation, or he sees the evidence is about to be spoiled or something, that would allow him to go in and seize the evidence without a search warrant in certain cases. But again, that would be a more interesting question of this third element as to whether a police officer has a lawful right of access to the object. If the object had been in like a backpack inside the car, that could have been different. But granted, then it wouldn't have been in plain view if it was inside a backpack. So that exception we wouldn't even been talking about the plain view doctrine at all in that case, because it would have been hidden inside a backpack. So the key here was just recognizing that all three of these elements were satisfied. It was made a little bit simpler by the fact that we were dealing with a vehicle, an automobile, which should just be a general rule to keep in mind when we're thinking about the Fourth Amendment. There's a lower expectation of privacy in a parked car on a public street. So it's not going to have the same kind of constitutional protections that things like the home, the hotel, the office, or luggage might have. So just as a general rule on criminal procedure fact patterns, when we're seeing vehicular searches and seizures of evidence, that reasonable expectation of privacy is going to be lower, right? And there's a lot of ways that the police are going to be able to search and seize evidence in an automobile where maybe they couldn't in something like a home or hotel, right? But enough on point number 2. We can move on to point number 3, which was worth 15% of the overall score on this essay. Here, the bar examiners were looking for examinees to conclude that the officer violated suspect's Miranda rights when officer arrested suspect and interrogated him without providing Miranda warnings and obtaining a valid waiver. Yeah, this was just the fact that we did have a custodial interrogation, right? We had a custodial interrogation. This is the key. Custodial interrogation. Remember, a person is in custody when he reasonably believes that he is not free to leave or otherwise terminate the encounter, and a person is subject to an interrogation when the police know or should know that their words or actions are likely to elicit an incriminating response. Here, with this second half of this paragraph, we saw that both of these elements are met, right? The suspect is handcuffed and he's being told that he's under arrest. A reasonable person would not believe that they're free to leave or otherwise terminate the encounter when they're being placed under arrest and they have handcuffs on. So definitely in custody. And a person, remember, subject to an interrogation when the police know or should know that their words or actions are likely to elicit an incriminating response. Well, here our police officer asked the guy, "Are these drugs yours?" That's, of course, likely to elicit an incriminating response. You're asking whether someone has committed a crime, so that would constitute an interrogation. So both elements were satisfied. We have a custodial interrogation being conducted. Miranda v. Arizona requires that police inform a suspect of their Miranda rights before conducting a custodial interrogation. Failure to do so results in a Miranda violation. So because this police officer in our fact pattern conducted a custodial interrogation without informing the suspect of his Miranda rights, that's where we get the Miranda violation, right? Officer violated suspect's Miranda rights. That was point 3, worth 15% of the essay, which takes us to point 4, which was worth 25%. So we have point 4A, which was worth 25% of the essay. Here, the bar examiners were looking for examinees to conclude that officers' Miranda violation did not taint detectives' subsequent interrogation. Okay, so we talked about this. This is just the key here was recognizing that the fruit of the poisonous tree doctrine does not apply to Miranda violations. So because this was worth 25%, let's do an example here and really flesh this out. Kind of the idea of the fruit of the poisonous tree doctrine and how this plays out, right, with typical violations. So for example, let's say, and just, forget this fact pattern for 1 second. I'm going to use a different example to kind of illustrate the point with something that's easier to see. So let's say that the police have a person in custody they suspect has committed murder. And let's say the police fail to give this suspect any Miranda warnings before interrogating him. And during the interrogation, let's say the suspect voluntarily confesses to the murder and reveals the location of the murder weapon that he used to commit the crime. So we have two pieces of evidence. We have the confession, right, which is just going to be statements. We have the confession and we have the murder weapon, right? So we have the confession and we have the actual murder weapon. So the police find the murder weapon based on the confession. Okay, well, remember, the confession itself in this case is going to be inadmissible in the prosecutor's case in chief because the confession was obtained in violation of Miranda, right? In this fact pattern I just laid out, remember, the police have a suspect in custody and they begin interrogating him. They ask him about the murder and they fail to give the Miranda warnings. So that's a clear, and then they get a confession. That's a clear confession obtained in violation of Miranda. We know that the prosecution cannot use that confession in their case in chief because the confession was obtained in violation of Miranda v. Arizona. But this still leaves the question about the murder weapon because they found the location of the murder weapon based on the confession. During the confession, the suspect reveals where the murder weapon is. So then they go out and they find the murder weapon. Is the murder weapon admissible? Well, the key is the murder weapon is admissible even though it's derivative evidence obtained as a result of the Miranda violation, because evidence obtained from voluntary statements, even if in violation of Miranda, are admissible. Even if it's derivative of the Miranda violation, if it's a voluntary statement, it is admissible. So evidence obtained from voluntary statements that are derivative of the Miranda violation, like the murder weapon, right? It's still admissible because the fruit of the poisonous tree doctrine does not apply to Miranda violations. So again, the derivative evidence obtained in violation of Miranda, which would be the murder weapon, is not tainted. It is admissible, right? That would be like a Miranda violation when the confession is obtained in violation of Miranda. But let's say that the confession is obtained in violation of the Fifth Amendment. Rather than failing to give the suspect the Miranda warnings, let's say the police officer puts a gun to the suspect's head and says, "Confess to this murder or I'm going to blow your brains out." Well, that's a Fifth Amendment violation. That's an involuntary statement obtained in violation of the Fifth Amendment, right? So that confession, of course, again, would be inadmissible, but any evidence obtained as a result of that violation, the derivative evidence, would also be inadmissible. So in that case, if we had a Fifth Amendment violation, the murder weapon would also be inadmissible as fruit of the poisonous tree. It's tainted, right? Once we have that Fifth Amendment violation, all derivative evidence obtained from that Fifth Amendment violation are also inadmissible under the fruit of the poisonous tree doctrine. So the Miranda violation, it's key to recognize that the fruit of the poisonous tree does not apply to Miranda violations. So that's kind of our difference between Miranda violations and Fourth, Fifth, and Sixth Amendment violations. Basically, the easy way to think about this is just the Supreme Court views Miranda violations as less serious than these Fourth, Fifth, and Sixth Amendment constitutional violations. And for that reason, when we have a Miranda violation, the fruit of the poisonous tree doctrine does not apply. And that was basically the key in this fact pattern, right? There was maybe an argument that the earlier Miranda violation, if we think back to point 3, where the officer violated the suspect's Miranda rights when the officer arrested suspect and interrogated him without providing Miranda warnings and obtaining a valid waiver, right? Could that violation have tainted the future confession that the detective gets? And the answer is going to be no, because the fruit of the poisonous tree doctrine does not apply to Miranda violations. So the derivative evidence, the second confession that's obtained, is still admissible. It's not going to be tainted from the Miranda violation because the fruit of the poisonous tree doctrine does not apply to Miranda violations. Now, the only thing we would have had to look out for here is if somehow the original Miranda violation, where we have the officer questioning the suspect, if that could have somehow been construed as a single sequence of questioning all the way through to when the confession happens, right? There is some case law out there where if we have one Miranda violation over here and the same kind of sequence of the custodial interrogation continues, and later we get another kind of statement or confession, if it's all one sequence, one unwarned interrogation, then this one over here could still be a violation of Miranda, going back to the original Miranda violation. But this isn't really derivative evidence obtained as a result of the original. It's just like one sequence, one long violation is almost how you could think about it. And that would be if we could see it as basically one interrogative process, one long sequence of questioning. But that's clearly not the case here, where we have the suspect being taken from the arrest scene where the original Miranda violation occurs to the police station for booking, where, remember, an hour passes before the detective even visits the suspect for questioning. So it's going to break this kind of sequence idea. It's not one single unwarned sequence of questioning. Further, the detective reads the suspect his Miranda rights. So it kind of breaks the sequence when the detective comes in an hour later and reads the suspect his Miranda rights. This is a new interrogation happening at this point, right? We can't construe this as one long, single, unwarned sequence of questioning, all the way from the officer's original violation to the confession made to the detective after Miranda warnings have been read an hour later, in a different time and location. It's not a single unwarned sequence of questioning. As such, the officer's initial unwarned custodial interrogation should not prevent the prosecution from using the suspect's later confession to the detective. The detective provided proper Miranda warnings and obtained the suspect's knowing and voluntary waiver before interrogating the suspect, so there's no Miranda violation when the detective begins the custodial interrogation. However, there is still a question as to whether the suspect invokes his Fifth Amendment right to counsel during the custodial interrogation. Remember, 5 minutes in, the suspect says this thing about maybe I need a lawyer. If the suspect invokes his Fifth Amendment right to counsel during the interrogation, we know there could still be a Miranda violation if the detective fails to cease the interrogation, which I imagine is going to take us to point 4B, right, which was worth 10% of the essay. Here, the bar examiners were looking for examinees to conclude that the suspect's statement that he might want an attorney was too ambiguous to require detective to cease interrogation. Exactly. Right, this was our final issue we had to deal with here. The key is, remember, to invoke the Fifth Amendment right to counsel, a suspect's request must be clear and unambiguous. This means that the suspect must articulate the desire for counsel sufficiently clearly, such that a reasonable officer would understand the statement to be a request for counsel. If the request is ambiguous, the police are not required to cease the interrogation. Here, the suspect's statement, remember, our suspect says, I'm not sure about this. Maybe I need a lawyer. This is not an unambiguous request for counsel. In fact, the most reasonable interpretation of this statement is that the suspect might be invoking his right to counsel. Under these circumstances, the detective was not required to cease the custodial interrogation of the suspect under Miranda v. Arizona. If the suspect wanted his lawyer present, he's got to say, Miranda v. Arizona puts the duty affirmatively on the suspect. They have to say, I want my lawyer. I need my lawyer. I'm not going to talk to you anymore until I have my lawyer. I'm invoking my Fifth Amendment right to counsel. It has to be clear, affirmative, unambiguous. Saying something wishy-washy, like I might need my lawyer, I don't know, what do you think? Should I call my lawyer? Should a lawyer be here? I might want a lawyer. I think I want my lawyer. None of this stuff is good enough. It has to be clear and unambiguous, okay? So for that reason, because the suspect's statement is too ambiguous, he says, maybe I need a lawyer. Police officer is not required to cease the interrogation. He can keep interrogating. So there's no Miranda violation there, which would mean because he had already read the suspect his Miranda rights, gotten the voluntary waiver, and then the suspect says, maybe I need, suspect never invokes any of his Fifth Amendment rights, so the police officer can continue questioning. This is how we get to the conclusion that there was no Miranda violation. So question number 4, should suspect's confession to detective be suppressed? Not under Miranda v. Arizona is the answer to question number 4, which was everything, I believe. Yep, we're at the end here with point 4B, which was worth 10%. With that was everything that the bar examiners were looking for in this criminal procedure essay from the July 2011 multi-state essay exam. So with that, I'll leave you all to it. I wish you the absolute best, and I'll see you at our next lesson.